Many are called. Please proceed.
And some actually answer and show up. Okay, this is for Ms. Eiffel. You noted that the average length of Section 2 cases is 2 to 5 years, and it's simply not sustainable. And that is why we need to pass the John Lewis Voting Rights Act. So perhaps you can tell me, how effective is the current Section 2 in protecting people's right to vote in comparison to the pre-clearance process that was in place under Section 5?
Thank you very much for that question, Senator Hirono. So let me clarify also, just given the last colloquy, the Supreme Court actually invited Congress to update the formula under Section 5. It did not strike down Section 5. And so I'm very hopeful that Senator Lee and others are willing to participate in a process to update the formula so that we can pass a new preclearance formula under the Voting Rights Act. The difference is that the preclearance formula allows us to stop discrimination before it happens by introducing a federal process that allows for a neutral review, whether the federal authority is Republican or Democrat in terms of the Attorney General or the district court in DC, to review an election law to determine what its racial impact would be. And that would happen before the law would be passed. Every provision of SB 202 would have gone through that process before it became law. Instead, the law was rushed through. It now exists. We have filed suit along with other organizations. We will litigate that case likely for more than a year. And during that time, there will be elections in Georgia. As I said, in the Texas case, we were still litigating in 2018 a voter ID law that was enacted in 2014. If we think that that's appropriate for a healthy democracy to hold scores or hundreds of elections in which potentially hundreds of thousands, if not millions of voters are affected, and that law may ultimately violate the Constitution or the Voting Rights Act or the Americans with Disabilities Act or any of the other reasons why voting changes have been struck down, then I think that's what this committee has to really focus with. As a matter of democracy, we need to deal with these matters before they become law.
I agree with you, Ms. Eiffel. In the meantime, though, the Supreme Court has before it 2 cases that test Section 2. And I know some of the arguments that the opponents of Section 2, they would like to very much limit the impact of Section 2. Bad enough that the Department of Justice under the Trump administration brought how many Section 2 cases?
I think it's 0, if maybe 1.
I think that the 1 would be about it. That would be the maximum. So it's hard enough under Section 2, but some of the arguments that were made, if the Supreme Court goes along with the arguments that were made to limit Section 2, that would make it even harder. You would have to show different impacts. You would have to show much more than what you currently have, which is hard enough to do under Section 2. Would you agree?
It would be utterly devastating. It would be utterly devastating, a blow to our democracy, a blow to one of the finest moments in this country, which was the passage of the Voting Rights Act in 1965. And when the Senate passed the Voting Rights Act in 1965, they were very clear that they meant to get at not only current forms of discrimination that existed in 1965, but the Senate report said it was also designed to get at ingenious forms of discrimination that might be created in the future. Congress was forward-looking. They understood that voter suppression would not go away. And to wipe out that history would be an affront to every martyr of the civil rights, voting rights movement, to Senator John Lewis, and to the many Black voters who actually feel demeaned when they're told that they can't give water to their elderly relatives standing on a line trying to vote.
That is what I call the kind of cruelty that is exemplified too often in these kinds of cases. So the Shelby County decision was a 5-4 decision, and Justice Ginsburg famously wrote, quote, "Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." Are you concerned that this court, with these 2 cases before it, will render possibly a 6-3 decision to further limit the Section 2 remedies?
Senator Hirono, I sincerely hope that the United States Supreme Court has seen what has happened since 2013 when the power of Section 5 was gutted, that they will understand, that they will be humble enough to recognize that there are things perhaps they did not know or understand that are happening in this country, and that they will read the record, that they will take account of what the reality is, and that they will respect what I believe President Reagan called the crown jewel of civil rights legislation, the Voting Rights Act, and ensure that it remains intact and an effective tool for combating voting discrimination.
Ms. Eiffel, I appreciate the dialogue I had with you, and I really appreciate the other, of course, Stacey Abrams and Ms. Anderson, whose books I read, and the others who have testified for the enactment of the John Lewis Act. I just want to mention one more thing, though. I've heard some comparisons to Hawaii voter laws and saying, well, Georgia is better than Hawaii. Oh, give me a break. For the first time ever, Hawaii had all mail-in ballots the last election, and we had the second highest percentage of voter participation as a result. This is why mail-in balloting is voting is so important, and why we need to look at what the post office was doing in the 2020 elections that made it that much harder, and the person who heads up the post office is still there. He needs to be removed. That is an editorial comment. Thank you. I think my time is up.
Thanks, Senator Hirono. Senator